Welcome to Laws and Scriptures 360. In today's video, we're going to be talking about 5 rebuttable myths of dissolution of marriages in Nigeria. The first one is that for dissolution of marriage to be complete, it has to be signed by both parties. This is not the case. Dissolution of marriages in Nigeria is first commenced by a petition in court, and the process is being served. Hearing date is fixed, hearing continues, and then judgment is delivered. It is upon an order nisi that the marriage is dissolved. And then after 3 months, upon application by the legal practitioner or by any legal practitioner or even by the parties, an order absolute will be issued. So you see, contrary to what we see in most of the Nollywood movies, that papers are brought and parties are told to sign, or one particular spouse will be telling the other, sign this and let me know that the marriage is over. Sign this paper, let me know. That is not how dissolution of marriages are conducted in Nigeria. It may be the case in other countries, but in Nigeria, the formal process of hearing in court must be followed, and the judge gives a formal judgment for the parties to be said to have been dissolved, for the marriage to be said to have been dissolved. Now, the second myth of dissolution of marriages in Nigeria is that if a party is unwilling for the marriage to be dissolved, that the marriage will not be dissolved. This is not the case, because parties, no spouse in law, under our matrimonial clauses, no spouse can be forced on the other. A husband cannot be forced on a wife, neither can a wife be forced on a husband. So, this is why, upon hearing of the evidence of both parties, the court, by his discretion, will now decide if an order necessary for the dissolution of marriage should be made or not. It is upon hearing, not as a result of either the willingness or unwillingness of any of the parties to the marriage. And so you can see that dissolution of marriage in Nigeria is not just dependent on the parties, but on the court that makes the order nicer, or the order for dissolution of the marriage. So if an unwilling party expresses his or her unwillingness for the marriage to be dissolved before the court will look at the merits of the case, just as every other civil proceedings. We look at the merits of the case. We look at the circumstances of the marriage to determine if the marriage should be dissolved or not. It is left for the discretion of the court, not just for the parties to the marriage. So, the third myth about dissolution of marriage is that if a party to the marriage, if both parties to the marriage agree, have a consensus to say that we don't want to be together again, we don't want the marriage to continue, and probably put it down in writing as a form of an agreement that the marriage is dissolved. This is not the case. Even if both parties agree that they do not want the marriage to proceed, or they don't want to continue again, now the agreement of both parties may reduce the length of time spent in court, but the formal process of filing a petition for dissolution of marriage must be made by a legal petitioner on behalf of the parties. And then the agreement that they both have reduced in writing may be tendered in court, which will now make the court to deliver a consent judgment, because they have both consented. But their agreement does not dissolve the marriage. It is the order of court that dissolves the marriage. Now, the fourth myth about dissolution of marriage is that an application for dissolution of marriage is made separate from an application for either custody of the children or settlement of property. This is not the case. When an application for dissolution of marriage is made, alongside the said application for dissolution of marriage, an application for the custody of the children of the marriage, if there are children in the marriage, can also be made. And alongside, an application for the settlement of the property of the marriage can also be made in the same proceeding. There is no need to now institute another proceedings, because an application for the custody of the children of the marriage and an application for the settlement of the property of the marriage are called ancillary reliefs sought by the parties. They are ancillary to the main relief for dissolution of marriage. So when the court is delivering his judgment on the application for dissolution of marriage, the court would also deliver the said judgment concerning both the dissolution of the marriage, the custody of the children, the welfare of the children, and the settlement of property. So all of them are all encompassed in the same petition. So you cannot apply for dissolution of marriage and separately apply for a petition or for an action for the settlement of property or custody of the children of the marriage. And then finally, when an order for dissolution of marriage is made, it is made in two parts, not just at once. That is another myth. When the court delivers its judgment for dissolution of marriage, the court first delivers its judgment and makes an order nisi. This order nisi is like a temporary relief for 3 months to see if parties will come together or reconcile within the 3 months. When an order nisi is made, yes, the marriage is dissolved, but the order becomes absolute after 3 months. That is when the marriage is completely dissolved. So upon an order nisi, you can say that the marriage is temporarily dissolved, not completely dissolved, until an application after 3 months of that order nisi is made for an order absolute. That is when the marriage is completely dissolved. And when the marriage is completely dissolved and the parties to that application, maybe after 6 months, they now decide that they want to come together, maybe they fell in love again. Unlike an application for judicial separation, both parties will need to go back and remarry, even if they were married before. As far as an order absolute is made, they do not owe each other any marital obligation. However, if they now decide to come back after an order absolute is made, they will require to officially get married statutorily and recommence their marriage relationship, because an order absolute upon an application for dissolution of marriage totally ends the marriage and absolves both parties from further marital obligation to each other. I hope you found this video helpful. Please don't forget to like, share, and even suggest, give your comments. Tell me, you can even ask your questions. Let's know what you think. Thank you very much for having me, and enjoy the rest